New York surprise law that goes into effect on April 1st, 2015. This has been a bit of a surprise for many providers that I've spoken with recently. They're not aware that this new obligation is going to be on them, and it's very important that we educate ourselves and adopt proper policies and procedures prior to the effective date. So for those of you listening prior to April 1st, 2015, congratulations on educating yourselves properly and hopefully taking steps to ensure that you are in compliance before the effective date. There's been a lot of confusion about what the surprise law is or where it's even found from lawyers alike. And it's in multiple different locations. It's in the New York State Public Health Law. Part of it is found. The New York Financial Services Law and the New York Insurance Law. There's multiple statutes that come into play that create for us our surprise law that is going to address surprise bills, which I'll define in a second, which makes sense because it's affecting our healthcare providers, and it also impacts insurance companies. Working together, the bill creates an onus on both sides, but I think in a positive way. So before we get into the specifics of the law, I just want to say that from my point of view as a healthcare attorney, this law is going to be very important to create on the patient the obligation of taking responsibility for payment, because this is going to make it very clear that the practitioners the patient is seeing, if they are complying with the requirements of this law, that they have done everything they needed to do as far as disclosure goes, and the patient should, will be held responsible for their payment obligations. So in the many instances that I see this come up, where I know it's not the frequent concern for many practices, but we have some patients that simply are not paying their deductibles or their co-payments, or if we are an out-of-network provider and we do balance bill as we're required to, patients just simply do not pay the remainder that is owed. And in this instance, you will now have support by law where patients are taking on the responsibility and will have to acknowledge that they are responsible for the amounts that are owed. So before we get into the actual law, there's also been a lot of questions, mainly from many of my dental clients, on whether or not this actually applies to them. And very explicitly, under the New York Public Health Law, this is one of the statutes that comes into play for the surprise law applicability. It states very clearly that it applies to healthcare professionals appropriately licensed or registered under Title VIII of the Education Law. And this is a list of those practices. So medicine, so MD, DO, physician assistants, chiropractic, dentistry, all levels of dentistry, physical therapy, some of you may be on the line, podiatry, very clearly covered, psychology. So we want to make sure that we understand what our obligation is if our licensure designation falls under this spectrum. Now, what is a surprise bill? Because that is what this actually entire regime that we're talking about today applies to. A surprise bill is a bill for health care services received by an insured patient, not necessarily actually as you'll see, but this is what it says, for services rendered by an out-of-network provider at a participating hospital or ASC where a participating physician was not available or the out-of-network provider rendered services without the insured's knowledge, or unforeseen medical services arise at the time the healthcare services are rendered, except where the insured elects out of the network provider. So very clearly, it will be considered a surprise bill if a patient is seen at a hospital where they would expect to have been covered, and the participating physician is not available, or the out-of-network provider sees a patient without the insured's knowledge. That would be a surprise bill, the bill that results from those services. In addition, and this applies to many of you who are not necessarily providing services at a hospital or ASC, surprise bill is where a patient has not given explicit written consent acknowledging they were referred to an out-of-network provider, and that the referral may result in costs not covered by their health care plan. So what does this come into play? What do we see here? We see that there is now a documentation requirement on the practice. Presumably, the referring provider who would know that they are making the referral. They may or may not know the participating status of the practitioner they're referring to, but there is now an obligation on the referring provider to get explicit written consent acknowledging that the patient is being referred to an out-of-network provider. And we'll talk more about the documentation requirements, but this is just under the definition of surprise bill under the new laws. In addition, a surprise bill is when an uninsured patient is not provided required disclosures and is treated at a hospital or ASC. There could be a surprise bill there as well. So how do we avoid surprise bills? This is the key, I think, one of the keys to this talk that we're going to have today. Avoiding surprise bills requires that certain disclosures are made to your patients. You are required to give your patients notice of the health plans that you participate with. Now, this should be by practice, and if it differentiates by provider, you have to list it by provider. It should be on your website. If you have a website, it must be on your website, and I would recommend you putting it in writing and promulgating it somewhere in your waiting room. You could also provide it in your patient forms that you disseminate if you'd like. Now, of course, this has to be kept up to date if there's a change in participation status. Also, you want to be specific about which particular plans you are participating in. Hospital affiliations. You are required, prior to the provision of any non-emergency services, and verbally, at the time an appointment is scheduled, you are required to disclose hospital affiliations of the practice and each practitioner specifically, which you may also want to do on your website. You are also required to disclose that available upon request by a patient is the amount or estimated amount of a potential or actual bill. That is very important. You are also required to provide notice that your fee schedule is available upon request, and they can request that in writing. Also, you are required to give the name, practice name, mailing address, and telephone number of any healthcare provider scheduled to perform anesthesia, laboratory, pathology, radiology, or assistant surgeon services provided in your office or referred by you at the time of the referral or coordination of services. So I'm going to say that one more time because that's very important. So you, as a practitioner, are required to provide the name, practice name, mailing address, and telephone number of any healthcare provider scheduled to perform any anesthesia, laboratory, pathology, radiology, or assistant surgeon services provided in your office or referred by you, and you have to give this information at the time of the referral or coordination of the services. In addition, you are required to provide the name, practice name, mailing address, and telephone number of any other physician whose services you will arrange and schedule at the time of any pre-admission testing, registration, or admission at the time of non-emergency services that are scheduled for a patient's hospital admission or outpatient hospital services. So there's specific requirements for pre-admission or hospital outpatient services as well. How do we avoid these surprise bills? Out-of-network provider is required to provide patients with a claim form for a third-party payer with a patient bill of service, other than a bill for patient's copayment, coinsurance, or deductible. So these are all things that you have to give to your patients in order to avoid having a surprise bill rendered. Because once there is a surprise bill that is received by the patient will have certain rights to dispute the amount owed. And we're going to get into that. Because what the surprise law does is it creates a situation where if a surprise bill is received, parties are entitled to elect to go to independent dispute resolution in order to get the final number on what's actually owed and who owes what. And we're going to go through the whole resolution process on today's call so you understand. Now, the resolution process is meant to be efficient. It requires physician involvement, actually, which I understand that the State Medical Society advocated for and was successful in implementing. And it is supposed to be done within the prompt payment law time frame, so within 30 days. Now, I'm not sure how this is going to actually be going into effect April 1st because we haven't seen all of the information promulgated at this point and how this is going to work, but we have a general idea from the statutes that are setting forth certain of the information. So the good news is for us that don't like to balance bill is that there is a prohibition on balanced billing where there is a surprise bill rendered, which might be one of the upsides for many of your practices that don't want to balance bill. So when an insured assigns benefits for a surprise bill, so meaning when one of your patients has given you an assignment of benefit and was not aware that you are a non-par doctor, you will not be able to balance bill that patient. You'll have to take the amount that is given to you by the insurance company, which essentially is creating a situation where you're paid as a participating provider. So while there's the non-harassment element on the patient because you're not authorized to balance bill, you will also be paid essentially at the fee schedule that is going to be set by the insurance company. And we'll talk about that as we get to the dispute resolution because that'll discuss how the fees are going to be determined on what will be paid. So when an insured assigns benefits for a surprise bill in writing to a non-participating physician that knows the insured is insured under a health care plan, the non-par doctor shall not bill the insured except for any applicable co-payment, co-insurance, or deductible that would be owed if the insured utilized a participating physician. So with a surprise bill, when the disclosures haven't been given, the ones we went through previously, you are looking at a prohibition on balanced billing. It is necessary for all practices, I believe, and referral sources to adopt proper policies and patient forms in order to avoid having surprise bills rendered. Your staff will also have to be trained on this, the disclosures that are necessary and when things have to be given to patients. So that way, again, we are not having these surprise bills rendered. Now, the surprise bill would be coming to a patient from a non-par doctor. So for all of you on the call right now that are participating, how does this come into play for you? Well, you are the ones who are referring potentially to a non-par doctor. So it would be on your end to get a lot of this paperwork completed. And it's not an absurd or burdensome amount of forms that you need signed. It's just a couple of others. If you're going to be making a referral to a non-par doctor, that the referral is to a physician who may not participate, and the patient is responsible for the cost, and there may be out-of-pocket expenses that are associated with the visit. So dispute resolution for surprise bills. For a surprise bill received by an insured, now this is important, an insured who assigns benefits to a non-participating provider. Now this is straight from the statute. The health plan is responsible to pay the bill amount, or they can attempt to negotiate a lower amount. And the health plan has to go through all these steps in order to be able to utilize the benefit of the dispute resolution process. If the health plan refuses to pay the requested amount, a negotiation does not result in a resolution of the payment dispute, the health plan will pay what it wants to the provider minus any copayment, deductible, or coinsurance. In this instance, either party may submit the dispute regarding the surprise bill for review to an independent dispute resolution entity, except, and again, this is what I said before, the health plan cannot submit unless it has attempted to negotiate and has paid some amount it determines reasonable. So some payment has to be made by the health plan to the non-par doctor, presumably, because a surprise bill has been rendered. In other words, the non-par has billed however much amount over what was it to be expected by the patient, or the patient didn't know what the amount was supposed to be. And the insurance company is now saying, I'm not paying that amount. I will pay you this lower amount. The physician at that point is entitled to request independent dispute resolution. And we'll go through the parameters on what amounts the independent dispute resolution will have at their disposal to choose. But the determination by the independent dispute resolution entity must be within 30 days of receipt of the dispute for review. Now, again, I'm not sure how this is going to work because I'm not sure if they're set up yet, but we'll find out because this is definitely going into effect as of April 1st. The independent dispute resolution entity shall determine which fee to accept, the non-PARS amount or the health plan's proposed fee. So whatever amount you want to bill, if it's $50,000 and the health plan wants to pay $500, the independent dispute resolution entity will go through the facts and will go through the factors that they're going to look at to determine which fee is going to be accepted. For a surprise bill received by an insured who does not assign benefits, so this is where the patient has a direct responsibility to pay the non-PAR doctor, or by a patient who is not an insured, the patient may submit the surprise bill. So in other words, they didn't have advance notice that you were non-PAR. They didn't know that they would be responsible for an amount. They asked you for information about the fee that you did not disclose, and now they've received a large bill from you that constitutes clearly a surprise bill under the law. The patient may submit the surprise bill for dispute resolution to the independent dispute resolution entity. The entity will determine a reasonable fee based on certain factors, which we'll go through. The patient doesn't have to pay the practitioner before submitting for review. So as you can see, the patient has nothing to lose by submitting this, because once they submit to the independent dispute resolution, you are now not going to be able to go after them through the regular means of maybe you use a collection agency or maybe you utilize a law firm, maybe we handle your collections for you. If that's the case, you would now be bound by this independent dispute resolution process, which once we see how this is going to work, that might be a good thing. It might be easier to get the patient to pay if you put them through this process, because it's a 30-day turnaround, supposedly, and then you'll have an independent party explaining to the patient why they have to pay your bill and what amount. Of course, the amount that you billed may be lowered, but we'll see. So who is the independent dispute resolution entity? Well, there's going to be a certification process by the superintendent and selection. They're going to use New York licensed physicians in active practice in the same or similar specialty as a physician providing the service that is subject to the dispute resolution process, which scares me a little because I'm not sure what the fee is going to be for this IDR, but we'll have to see. The standards for dispute resolution process are going to be promulgated by the superintendent. So I haven't seen those yet. Now, these are factors that are going to be considered in an award for how much money is going to be given for the surprise bill in the dispute. Fees paid by other plans to this practitioner is going to be considered. Fees paid to other practitioners by the same plan. So what's the average fee? The level of training, education, and experience of the physician's usual charge for comparable services, the circumstances and complexity of the particular case, the individual patient characteristics, and the usual and customary cost of the service, which means the 80th percentile of all charges for the particular service performed by a provider in the same specialty provided in the same geographical area, as reported in a benchmarking database maintained by a nonprofit organization, which is going to be the fairhealth.org. And if you haven't been to their website, you can go to their site and punch in a CPT code and see what the average amount of payment is in your geographic area, which is very, very helpful and a very different situation than what we had with Ingenix approximately 8 to 10 years ago in this state, where the usual and customary was not appropriately calculated. So here you can go to Fair Health and take a look and see what the average rates are for certain services that you're offering in your office. Payment for independent dispute resolution. If it's an insured patient, the insured and health plan, if they win, the non-participating doctor is going to be responsible for paying for the IDR process. So not only are you getting less money, you now also have to pay for the IDR, which is an incentive for you not to have these disputes, of course, or to accept a negotiated rate by the insurance plan. They're basically pushing you to do that. Insurance and the non-par doctor wins. If you win and your fee is determined appropriate, the health plan will pay for the cost of the IDR. When settlement occurs, meaning both sides lose, because neither one has won a victory, payment shall be evenly divided and shared pro-ratably. So this is who's going to be responsible for payment of the IDR. If it's not an insured patient and the patient wins, that means the patient wins and there's going to be a lower amount owed. It doesn't mean zero is going to be owed. It means a lower amount will be owed. The non-par doctor is responsible for paying. The doctor wins. The patient is going to pay, except where there's a hardship shown. And the hardship regulations are not available yet. So you may not even want to go through this process. Well, you will, because there'll be a certain amount awarded. But and you'll just see, of course, the majority of your patients are not going to utilize this. I mean, if you think about your patient population right now, what percentage of it are actually patients that give you a hard time on paying? And if you think about that very small subset of patients, you'll understand, hopefully what limited impact this is actually going to have. There aren't going to be that many patients, I don't believe, that are going to avail themselves of this process. But if they do, hopefully it'll be a much faster resolution to payment disputes. If you do have your forms in place and there's proper disclosure, then the amount of your bills are not going to be questioned regardless. So this is actually part of the surprise law. This is a prohibition on certain conduct by insurance companies, which we always like to see, rules being put in place for them. So unfair claim settlement practices. No insurer may, as a general business practice, knowingly misrepresent to claimants pertinent facts or policy provisions related to coverage at issue. So if there's a miscommunication, it looks like it's intentional, as to what's covered and what's not, then that will be an unfair claim practice. If there's a failure to acknowledge with reasonable promptness pertinent communications as to claims arising under its policy, so let's say that you received pre-approval, that could be something that would come up here, and then they're saying that it was not pre-approved, unfair claim settlement practices. If they fail to attempt and implement reasonable standards for prompt investigation of claims, or if they're not attempting in good faith to effectuate prompt, fair, and equitable settlement of claims. So if you find that you're having trouble getting paid, this will be unfair claim settlement practices, which will not be constituting a misdemeanor, meaning that it would be a higher issue for the insurance company, and each individual instance will be treated as its own as per the insurance laws, and the insurance company will be looked at. So there's now that. Jury and judge, the independent dispute resolution entity, whatever they determine will be binding and admissible in court. So once you go there, there's no turning back. You're going to know what the amount's going to be that you're going to be owed. The surprise law does not apply where physician fees are subject to schedules or other monetary limitations. So workers' compensation, for instance, does not, this surprise law that we just went over on if there's a bill rendered, that certain policies and procedures weren't in place, and you need to get the patient authorization on understanding they're being referred for out-of-network services under workers' comp, does not apply at all. And also certain emergency services, which we're going to go through right now. This law does not preempt other laws, which means, same thing with workers' comp, which means that workers' comp has a specific set of rules that dominate how payment will be, and this law does not trump the workers' comp law. So there are no other laws that are related to payment for the majority of other areas for the services being rendered under, because if you're a participating provider, your relationship with a carrier is contractual. And if you're non-par, this law is going to be what's going to be governing what you can charge and what you can't charge and what disclosure has to be in place. So that's why this can apply to major medical. Emergency services have special rules. Where a participating provider would have or could have been available under ER conditions, you could have a surprise bill here. If the insured patient we're a healthcare plan only responsible for paying a reasonable amount, not more than the participating provider would receive for same services. So if you're in an emergency setting and a patient comes in that's insured, you are not allowed to receive more than what a participating provider would have received for the same services. Now, if you're not happy with what the insurance company has actually paid you, again, this independent dispute resolution process is available for you to avail yourself of and to say, you know what, Oxford or United, Blue Cross, Aetna didn't pay me enough for this. I'm out of network, I perform services at the hospital, and I want to be reimbursed at a higher rate. You have every right to go to IDR. Whether or not the fee is going to be seen as reasonable that you're looking for, that's going to be judged against the factors that we discussed a few minutes ago. How does it compare to the usual and customary? How does it compare to rates that you receive from other carriers? Can you substantiate the amount that's received? For non-insured patients, patients may submit for IDR, and they do not have to pay for the submission. So meaning that you don't have to be paid first. The patients can go straight to IDR for the amount that they're being billed. Emergency services that are exempt from the surprise law. The IDR process is not going to apply for any of these CPT codes. So if you're billing any of these codes, I'm not going to read them out, you can see them here, then it's not going to apply when the amount billed is equal or less than $600 if billed in 2014, which is not applicable, with an annual average inflation rate adjustment. So that 600 is going to keep going up annually, presumably, if the inflation rate allows for it. And if your billing equals that or is less than that after any applicable coinsurance, copayment, or deductible, then this will not apply. Whatever amount you're charging is going to be seen as reasonable. Also, if the amount for any such CPT code does not exceed 120% of the usual and customary cost for the code, for the service. So you'll know if what you're charging is reasonable if you're within these realms. If you think that these are not reasonable amounts and your time is it's necessary for you to charge substantially over what these amounts are, then you certainly can, and you'll have to see whether or not the patient agrees or the carrier agrees and pays it. And if not, then you'll end up with the IDR process. So for these codes, healthcare plans can ensure that there's no additional out-of-pocket expenses for insureds from the non-participating provider than if by a participating provider. And that's the point. That's why it doesn't apply. The exemption does not apply where an amount for any specific code exceeds $1,200. So if you're billing more than $1,200 for any one service in the emergency setting, then you will know that you are fair game for the IDR process. So just to kind of bring us back to where we started with the overview, and to wrap up here, because I try to keep these webinars at lunchtime short, because I know everyone has to work, so we're going to stay right in the half an hour range. You want to understand what your disclosure requirements are to avoid the rendering of surprise bills if you can. Especially if you're a non-par physician listening, this is a great opportunity to have in writing the legally approved forms, I don't want to say the forms, but legally endorsed concept that the patient has signed off on taking financial responsibility for out-of-network bills. And with that, I think it's going to be very difficult for these patients to dispute. They're going to be acknowledging that they knew you were out-of-network, they knew that their insurance wasn't covering necessarily, and that they may be responsible for the fee. And it's going to be commonplace for patients to be signing these forms at their participating provider's office, because the participating provider is going to hopefully be adopting these forms in their intake process and also upon referral. And also for the non-par doctor to be getting these forms signed prior to rendering services and making it known that their fees are available for review prior to patients being treated. So what that requires us to do, of course, hopefully before April 1st, which doesn't give us much time, is we have to get our fee schedule ready and available for what we will be charging our patients. And you don't have to disclose your entire fee schedule. You can disclose just for that one particular service that the patient is coming in for if you would like. certainly, and that's only if it's requested. If a patient is not requesting your fee schedule, you certainly don't have to leave it out in the waiting room. It's only upon request, but you do want to let the patients know that it's available if they want to request it, and you do need your forms in place for the remainder of the disclosure requirements, including the health plans you participate with and also your hospital affiliations. So you want to adopt proper policies, you want to train your staff, you want to administer forms, and you want to enforce, as a general practice, your surprise law requirements. So, of course, for those of you familiar with our firm, we do try to make forms available and help you with your intake process. The forms are available on our website. We are charging $315 for the policy and for the multiple procedure forms that you may need for your patients. So this is a quick link to our website, healthcarepracticecompliance.com. And I'll show you our website for those of you who haven't been here. This is our website. Hopefully you have checked it out. All of the newsletters, which many of you who are participating today get our newsletter, are available on our website. They're mostly up to date. Sometimes we update sporadically. But here's the compliance form page, and you'll see that our out-of-network disclosure forms, surprise bill forms, are right here. They're listed at $340 because that's going to be regular price after the end of the month. But they're $315 now, and it's very easy for us if you order online because then we don't spell anything wrong when we customize your forms for you. So I'm available for questions on this topic or any other topic related to your practice or not. If you have questions not related to your practice that are legal in nature, I'm happy to help you as well. So feel free to give me a call. This is my contact information. Let me just see here. And if you're not on our newsletter and you'd like to be on it, it's a free Q&A that goes out twice a week. Please feel free to email me, or you can sign up directly on our website. I hope that this was a helpful overview for you, and good luck with complying. We're happy to help if we can, and I will see many of you hopefully soon. And if you have other topics you'd like us to cover on our webinar series, please feel free to email me.